Good morning, Judge Glacier. It looks like we have representatives for both parties as well as the court reporter ready when you are.
I'm ready. Thanks, Morgan. All right. Good morning, Council.
Good morning.
Good
I
morning.
think everybody's here. Oh, good. Our court reporter, Ms. Roberts, is coming into the room. So I'll wait until she's in and ready before I call the case.
Kicked me out for a minute and then let me back in.
Okay, you're all set. Are you ready, Ms. Roberts?
Yes.
Thank you. All right. Good morning again. Let me call the case. It is Hassan Ahmad versus the University of Michigan. Case number 17170MZ in the Court of Claims. We're here today on plaintiff's motion, which is styled as an objection and motion to compel and request to hold oral argument. So part of that is already granted because here we are, we're holding oral argument.
50% there. There we go.
Right, you're halfway there, right, exactly. Counsel, would you please identify yourselves for the record?
Yes, Judge. Good morning. Philip Ellison appearing on behalf of the plaintiff this morning.
Good morning, Your Honor. Brian Schwartz on behalf of the University of Michigan.
Good morning again to both of you, and thanks for being here. Well, I read both of your submissions, and let's cut to the chase here so that we can make some progress today. This dispute is about the Vaughn Index, as I understand it, and whatever I say when it's your turn to speak, please correct me or send me on a different track if I'm going off in the wrong direction. But here's how I see it. We are here today to discuss the adequacy, the completeness, the helpfulness, if I can use that term, of the Vaughn Index. The Vaughn Index, as I understand it, is supposed to be a help to the court, essentially, or ultimately, because it allows the court to make a determination on a document by document basis as to whether or not there is a legitimate, and I'll say legally legitimate reason to withhold a document from production under the Freedom of Information Act. So quoting from one of your briefs, and I don't remember which, but I think it's whichever one of you said this, I think it summed it up aptly. The purpose of a Vaughn Index is to give the court enough information to determine whether the requested documents are exempt. Okay. Now, the court...
Judge, I didn't hear the last word you said.
Oh, I'm sorry.
The requested documents are what?
Exempt.
Okay.
Exempt.
Okay, sorry for the interruption.
No problem. Glad you stopped me. I've looked at the Vaughn Index. I haven't gone through every page. I see that the University of Michigan has preserved its objection under the Community Foundation Act and the Library Privacy Act, which to me are at this point irrelevant because you, Mr. Schwartz, you filed a leave app. The Court of Appeals didn't grant leave. And as I understand it, you didn't file an application in the Supreme Court, at least not that I could see that you filed. Am I right about that?
Correct. We didn't file an application now to go to the Supreme Court again.
I'm sure you will, but yeah, yep. I'm sure you will. But I mean, so, but where are we now today? I'm looking at two cited exemptions that are meaningless to me, absolutely meaningless. They've been dealt with, and I'm not going backwards on those. You also include a third exemption, which is out the window at this point, although the Supreme Court may consider it, I guess. The records are exempt from disclosure by operation of the gift agreements entered into by the university in Canton. To me, that's rehashing the issue that went to the Supreme Court a couple of years ago now, and I'm not interested in that one either. That one doesn't tell me what to do with these documents. So the only cited objection to production that I have to work with for all of the documents, basically, is that the records contain information of a personal nature. And I think you mean to say here, I just picked a page randomly, and public disclosure would constitute a clearly unwarranted invasion of Tanton's and others' privacy. And certainly that's the objection, I think, that remains in play, given the status of the courts, of this court's rulings and the Supreme Court's non-ruling and the Court of Appeals ruling as we sit here today. The problem I have, Mr. Schwartz, is I have no idea how to put that objection exemption into effect, because I know that there are indeed certain things that may be in these documents that constitute personal information, the disclosure of which could theoretically constitute a clearly unwarranted invasion of privacy. But those things, as I go through the case law, and this isn't my first FOIA case, those things are few and far between. Those particular items that the disclosure of which could or would cause a clearly unwarranted invasion of privacy have been described as, quote, intimate, embarrassing, private, and confidential details about someone, such as, in some cases, addresses, dates of birth, and phone numbers. Now, I have names, for example, are not generally held, at least I can't find any case law where they've been held when this type of an exemption is invoked to be information of a personal nature, the disclosure of which could lead to a clearly unwarranted invasion of privacy. So here I am trying to figure out what to do, because you haven't given me, I do agree with Mr. Ellison that you haven't given me enough to work with in order to determine whether a particular document or series of documents are in fact exempt. I'm not going to hold you in contempt. So Mr. Ellison, you're now like you're 1 for 3. Let's put
I
it
would
that way.
never, I was simply musing on that as part of my brief. As
Okay.
the court saw in the brief section, we're seeking some clarity here, not, you can't submit 150 pages and be in contempt as far as I'm concerned.
Okay.
So,
All right. So to the extent that that was a real world request, that's denied. Okay. So here we are, and the court needs help. I am not going through how many thousands of pages is this? I mean, this would be my life for the next 3 months, and I don't have time anymore for that.
Yeah, it was estimated, and we didn't do a page by page, but some estimation of about 25,000 pages.
Okay. Well,
And I didn't run it through a counter because some of these are clippings or handwritten
Right.
notes on paper that we're going to be careful with when you're going through it.
right. Okay. So here's my question. Mr. Ellison, you can speak if you want to, but I think it would be helpful for me to first throw the ball into Mr. Schwartz's court and ask him to respond to a couple of things. And then of course, I'm going to let you speak and
Court's
correct
prerogative.
anything.
no problem.
Okay. All right. The first thing I want to talk about with you is why I shouldn't consider the university to have waived any personal privacy objection to boxes 15, 16, and 17. And the court is leaning very strongly toward viewing the fact that those boxes were open for a considerable period of time, open to the public, as a waiver. If you wish me to make that ruling now or within, the next few days, I will make it so you can appeal it. But if you wish to supplement the record with legal or factual argument, I will also permit that to occur. So what's your pleasure? Let's talk about the waiver first before we go into the more difficult question.
Sure. I think we might have briefed this, and it's been a while since I agree that 15 to 17 are slightly different, in a different universe than 18 to 25 because of the nature of the fact that they were open. But we have, as we've argued, Tanton asserted his privacy over those documents. These were his personal documents to begin with, and in our position is that they remain personal, and that there is no waiver of them. Just because they were open, it's not much different than having, and I don't know if we've used this in any of the briefs we filed since you've been on the case, but it's not much different than, my son leaving his backpack in a public area. Anyone can go into it during the 2 hours that he leaves it in that public area. But when I go and get that backpack, you could assert the privilege, you could assert the personal privacy over everything that's in that backpack.
Okay, well, that's an interesting argument. Mr. Ellison?
So Judge, I guess what I would ask would be is, you just kind of hinted towards doing a bifurcated aspect. What I'm seeking to do by the motion, by this Vaughn index, is not to bifurcate. I don't want to spend another trip. I mean, this case is already 5 years old as it is. If it's going to go up, and I suspect it's going to go up, I'd like it to go up as one case for full and final decision. But as to 15, 16, 17, I guess I don't know the answer sitting right here, because there's been no case law that I could see that says, and using the example, I think Brian's example is an excellent one, would be is that the fact that it was potentially open, I don't know whether, and frankly, if they were accessed, there's a doctrine the federal courts have applied called the public domain doctrine, that once the documents enter the public domain, you can't assert an exemption ever again on those documents because they've been opened up and made available to the world. There could be an argument, and I don't want to help my opponent, but I want to muse on this for a moment, would be as if those documents were provided to the public, then that public domain doctrine would apply and there would be a waiver. There'd be a complete aspect of it. I don't
Okay,
know.
well, go ahead.
I was just going to say, I don't want to snatch victory from myself here, but I don't see how any of the exemptions apply. And so I would much rather, I guess, and I can't believe I'm saying this out loud, would be is rather have them go and assert specific exemptions rather than waivers, because exemptions are a far stronger basis by which to decide this issue rather than an issue of first impression on waiver.
Okay, I'm gonna come back to why I'm thinking about splitting it, but let me ask this: has there been any discovery on, for example, whether or not the public did access, or any member, even one member of the public, accessed these boxes while they were available to the public? And I don't even know if such records are kept at the library.
That is, I will represent to the court that I have put together discovery requests for that. I have not propounded those because I wanted to see the outcome. I filed this motion, I think, back in November. I wanted to see the outcome of this process first before going through, making the university go through 25, about 3 boxes out of 11, a third of or a quarter of them to tell me when or if they were accessed. Because the court could have granted the relief, or could potentially be granting the relief through this motion or this process going forward. So I will represent, I want to ask that. I've drafted discovery requests to do that, but I've held off on issuing them.
Okay, well, okay, so we'll put, Mr. Schwartz, anything else you want to say on waiver before we put that aside for the moment? But we're
No, Your Honor.
Okay, thank you. All right, so in terms of the exemption, the personal privacy exemption that's been invoked, it seems to me there are a couple of options here. I've now told you that I'm dissatisfied with my ability to apply that exemption because I don't have enough information. I simply don't. So I can just order that everything be disclosed, which unfortunately, Mr. Ellison, I don't think I want to do. I want to give the university another chance to either give me more information or give me a proposal that would enable me to make a reasoned, thoughtful, fact-based decision on these documents. Now, my research into what to do in this situation with an inadequate, incomplete, or inadequate Vaughan index has led me to a number of federal cases, and I'm sure you guys are aware of some of them. But one of them in particular, Lardner versus FBI, 852 F sub 2nd, 127, from the District Court of the District of Columbia, 2012, has a description of a representative sampling technique that the court ordered in that case, representative sampling of the documents. Are you both familiar with this concept? So I don't have to lecture you about it.
I'm familiar
Not
with
in
the
the concept of
concept.
FOIA, but we've done that before with other discovery issues.
Okay.
Yes,
Schwartz,
I'm
can
not
you
familiar with
repeat
that
'cause
case,
you
but
are, can you all not speak at the same time? Because I'm not going to get it all down. I can only write one person at a time. Okay, Mr. Schwartz, can you repeat what you said and please speak one at a time?
Sure. I think we actually might have been saying the same thing at the same time, but I'm familiar with the concept of representative sampling, not familiar with that case.
I concur.
Okay. All right. So that's one option. Which would, if we were to use that option, what I would say is the two of you meet, confer, and decide what sort of a representative sampling proposal you wish to make to the court. I will approve probably anything you guys agree on. So that's one. If you can't agree, then tell me individually how you would propose a representative sampling to proceed.
Your
go
Honor, if
ahead.
I may raise
Yeah.
an issue about that. So this is in a normal case, it's when there's an issue of like a client holding, having documents that are trying to withhold. It's easy. I have a copy of them on my computer, and the question is whether it's leaving my computer and going out the door. This is something I need to take back to my client because Bentley,
Oh, yeah.
these documents, when we reviewed them, I had a team of people go over to the Bentley. We didn't actually leave the building. The documents don't leave the building and they're not digitized. So I'm not sure if this, they're obviously, they have all sorts of policies to prevent. You can't just, take the, the final four banners and take them home and look at them. The ones that are at Bentley, you got to, they protect, they want to make sure that everything's preserved there. So I don't know mechanically how, if this is doable, but I understand then I can take back to my client and discuss this option.
Yeah, and obviously I'm going to give you time to do that and time for you to meet and confer. I'm not asking for you to do anything today. I'm just throwing ideas out there basically to throw you a life raft, Mr. Schwartz, because I don't want to today order disclosure of all of these documents without giving you a better opportunity or a bigger opportunity to tell me why the personal privacy exemption applies. Now, my thought, circling back to the waiver argument, was that perhaps cutting back on the number of documents by 3 boxes could make this a less onerous task. That's one thing. And if I'm going to rule that there's a waiver, there's a waiver. I mean, that those 3 boxes get disclosed. And it may be, and I've given this a lot of thought. It may be that once those boxes are disclosed, we have examples of what may or may not have been personally private information that could, you could invoke then with regard to the other boxes. But again, I'm just thinking out loud and trying to come up with ideas. So my idea on that, I'm giving you the representative sampling. I'm giving you an opportunity in a minute to tell me something else, whatever else you can think of, the two of you. I am going to say that that I do want waiver considered, but I'm going to throw that back at you and tell you that I want more briefing on that and I want some discovery on that. So I can set a discovery timeline just in terms of waiver to speed it up. Mr. Ellison, like I would think 60 days is plenty. 56 days in the parlance of the Michigan court rules. But okay, you've heard my thoughts. Tell me where you are, Mr. Schwartz.
Your Honor, one of the, as I mentioned, I mean, I think the representative sampling, I think could be a good option if it feasibly works. I mean, the other option is if I can't, if there's an issue with the representative sampling, kind of having the documents leave the door and go to the court or some sort of special master, it could be a kind of like a modified representative sampling. We do an uber detailed version of an uber detailed version of some of the categories of documents that we have on the bond index. If we had done that for the entire bond index, we would have been spending months pulling it together. But we could have a more detailed. One of the concerns I have about putting too much detail in this is I don't want to create a bond index or more detailed, say, representative sampling bond index, I'll call it, that then provides too much information that essentially destroys that. Then there's an argument that you put too much in there, therefore you waived the privacy objection by having too much detail in there. You put your whole social security number in there, therefore you've made a waiver argument there. So I don't, that could be kind of like a hybrid representative sampling / more robust index option. And that's just something I thought of off the top of my head. But that's another, if anything else comes to the top of my head, I'm definitely willing to share it.
Mr. Ellison?
I'm going to be blunt. I don't really like the representative sampling idea. I mean, not to be the deflating lead balloon in the room. The problem I've got is that even if, say, we picked a box, right? Let's just pick like box 17, right? Box 17 is not necessary. These aren't identical boxes. I don't have the same identical records in them throughout all the boxes as time went on. And the Vaughn Index here, for example, provides a lot of its correspondence in the early years. In later years, it turns into other types of documents, such as like meeting minutes and organizational documents of the organization. So I'm not sure a sampling is going to give us, it might give us a little better, I mean, maybe what I call a half step forward, but it doesn't get us a full step forward. So I'm paused by that. I don't want to say no, but I'm paused by that.
I was going to say, what about a representative sample of each of boxes 18 through 25?
Well, the other thing I was going to suggest is if we're going to do that, one thing the court does have the authority under the evening news is to order it, rather than them spending the time going through and identifying, making a more detailed Vaughn Index. You can order the production of documents to me just as counsel under a protective order that is not considered a disclosure. It's the three options you have under evening news, and they're further refined by a case. The first name on it's Kalamazoo, but I'm blanking on the rest of it right now. That's refined a bit by that decision. But what you can do is you can order those disclosures to me and me alone. I can't give them to my client, and then Brian could go through and say, hey, here are the things we would propose to redact on an example like this. And if the redactions are minor from that one particular box, we might be able to stipulate to the production, because as much as my client wants these documents, and I think the court gets this sense, is we don't want his social security number. I mean, we don't care about telephone. Of course, there's going to be some oddball redactions on things as with a production of this size. What we want is the substance of the documents that are in there, not necessarily these strange oddball ones that sometimes filter through in these circumstances. So that may be the other way to go about it is rather than, document, to come back and say, okay, on page 4 of box 18, there is a social security number. Yep, no problem with that. On page, et cetera, et cetera, et cetera, down the line. Now that does put more work on me, and it puts more work on, Mr. Schwartz on this as well. But at the same time is that might move the ball along for us to understand, because my biggest concern, and Judge, I think you said it right. What I don't want to have happen is I could have just simply filed my motion for summary judgment or summary disposition on this. And what I didn't want to have happen was the university come back and say, oh, well, there's social security numbers, or there's things intermixed in there. I want to know precisely on what page, what exactly the exemption is, because a lot of times and again, I don't mean this negatively towards Mr. Schwartz by any means, but I tend to find the government over redacts. From a plaintiff's FOIA attorney, that's my biggest complaint. They're over redacting. I don't want to have those surprises come to me at trial. So I guess as I've just been kind of talking along right here, those are some other options would be either do another Vaughn index that's more detailed, that specifically lists the exemption. Try this if you're going to do a sampling, use the evening news disclosure method rather than a sampling Vaughn index, and then go from there. And the court could then reserve the issue with save a production of so say you order production of box 15, for example, under this evening news. That would give us an appropriate amount of time then also to deal with the waiver argument and waiver drafting of the waiver briefing that you're seemingly going to request from us, that you've telegraphed that's coming our way. So that's my 3 cents on a 2 cents problem there. So.
Okay, thank you, Mr. Schwartz.
Yes, I mean, on the to follow up on the first point, and I do realize the boxes are different, and I'm looking this way because the index is on this screen. I mean, there is a way to do the kind of the representative Vaughn, more detailed Vaughn index by agreeing on kind of different categories, not necessarily pick a little, pick each box or something like that, but the different categories of documents. Because some correspondence, I realize, you might be more inclined to say, this is him talking about his personal views, has nothing to do with the University of Michigan at all. That might be different than him writing comments on a newsletter, or he writing his own personal thoughts on a newsletter that he has received. And those personal thoughts might be more likely to be protected than the newsletter he's reading. So it could be done that way, where you're looking at some correspondence, and there are lots of different categories of documents. So there could be pick a little bit of column A and a little bit of column B. I don't think the evening news, I'll just refer to that the evening news proposal that Mr. Ellison put out there is workable, because our whole idea is that these aren't ones that even anyone at the university puts their eyes on. The only reason I looked at them and some of my team looked at them is because we were required to do so. I think that Mr. or Dr. Tanton's whole view is that no one should look at these, not even the people at the university should look at these. So I think it's somewhat different than the normal situation when there's an exemption, but these are documents that are being used on an everyday basis. But then there's a question about whether the attorney can go in there. Plus, logistically, with the restrictions on getting on campus and getting into the Bentley to use these isn't as simple as just providing a copy of them. I can't provide a copy. I couldn't take any copies out of the library with me.
Okay, what I'm hearing is that there might be consensus of a sort for a representative sampling procedure. And my current, where I am now is that you two are experienced and thoughtful and seem to get along. So I see no reason that you two shouldn't caucus sometime in the next couple of weeks and see what you can come up with regarding a possible representative sampling order. Mr. Ellison, I'm not going to make them produce for your review, or I'm not going to skip to that step yet. I mean, I think that that's in the back pocket as a possibility if we can't get anywhere with representative sampling, but it seems to me you might be able to figure something out that you can agree to. Or, Mr. Schwartz, I'm going to have really no alternative but to tell you that you have to make a list of the reasons that the documents, or a list of the material contained in the documents about which you intend to invoke the personal privacy exemption. And they can be big categories, but they have to, well, let me take that back. They have to be specific categories, far more specific than what what I see in this Vaughn Index. I have a feeling that's going to get us almost nowhere, because I think that's going to take a lot of time. And I think my preference is to do a representative sample, potentially of all boxes, or those that you can agree on. So unless I hear a terribly persuasive argument to the contrary, the court today is inclined to send you out with 2 assignments. Number 1, meet and confer regarding a representative sampling procedure. And number 2, embark on discovery if you need it regarding waiver, and provide the court with some law regarding waiver within the next 56 days. If that's too short, the court, you know me, I'm not going to stiff you on time. I just want to get things moving here. And I, so comments? And I'm going to ask you guys to write the order too, so that we don't have to go back and forth with it.
Sure. First, do you want us to write an order regarding those 2 assignments? That should be pretty simple, because I was writing and I could actually read my handwriting. One of the benefits of doing this over Zoom is I read. If I'm on open court, I can never read legal pads.
I'll put that on the list. I'll put that on the list of the advantages of Zoom, that I'm trying to get my colleagues to understand that there are advantages to Zoom.
Oh, I tell your colleagues, I love Zoom. I wish we never go back, but that's my 2 cents. But anyway.
But the other question I had is, I know you mentioned discovery and then some briefing, and it probably makes sense to have the briefing done after discovery, because I'm imagining we would talk about the stuff that came out in discovery. So we could put it in, Mr. Ellison and I could figure out a certain period of time after that discovery that we'll have like cross briefs or something like that.
That sounds good to me. Whatever you guys come up with. Mr. Ellison?
I guess, Judge, I don't have a problem with that. I mean, I'm not a big fan of the sampling, but maybe with Mr. Schwartz and I batting it back and forth a little bit, maybe we can come up with something that's workable, that will cover the gambit. The only thing I would suggest, I know as a Court of Appeals judge that you are, prior to taking the helm of this court, 56 days is an awful, I mean, my guys have been waiting for 5 years for these documents, and this is supposed to be done under the statute on expedited in all possible ways. Now, I also don't want to cut my legs out from underneath me, because I'm a lawyer too with a busy practice, but I'd like to get something sooner than later. And my only other real concern is that, I expect is the university is going to appeal regardless of what we do here, which means more delay, more delay, more delay. So I guess if we do this, I'd like to do this, not an unreasonably fast speed, but I don't want to spend the next 5 months going over this stuff. I'd like to have something done maybe even in 45 days or 30 days, as opposed to, and maybe we make the sample smaller rather than larger, just so that we can do this on a more timely basis. That's my only pushback.
Okay, just as a reminder, I'm still a Court of Appeals judge. I still
Oh,
have.
I'm aware. Oh, I'm aware.
Yeah, I still have my Court of Appeals docket. So I haven't lost, thank goodness I haven't lost that role.
Court of Appeals judges have that 56-day number just at the tip of their tongue all the time. So, but
Right. You know, I would think, and the reason, Mr. Ellison, that I came up with that, it is generous to the university, but it was generous to you too. And my thought again goes back to COVID. And I heard Mr. Schwartz talk about restrictions on library access at this moment, which I presume are to a large extent COVID related. And I don't know how difficult it is to get into that library. I know that I'm teaching this semester at Wayne, and we're on Zoom this first month, but once we go back to live teaching, it's a hassle to go there every day, the days that I teach, with the check-in, with the testing, with the this and that, and everything is just slower, especially at a university. And so that's why I said 56. But if you guys think you can do it seems to me that in normal times, normal life, this discovery could in fact be done in 28 days, but I padded it because of COVID. So, you know, if you can do it faster, that would be lovely.
I guess, Judge, if I can leave it like this, I'd like to work with Brian. I mean, I want to be reasonable with Brian. I don't want to cut his legs out from underneath him. I want to make sure we all need time on stuff as lawyers on this, but I also don't I guess my thought would be is, so long as we leave here with the understanding we should proceed on this as fast as we reasonably can, reasonably being a generous word going forward. And if we have that understanding, and if that ends up being 56 days, it ends up being, but I guess I'd like it to be that's not our starting off point in from Mr. Schwartz's and I discussion, and we'll work something out between the two of us then.
And Your Honor, you are correct. A couple months ago, I don't know if the library restrictions have changed, but a couple months ago, because of COVID, the hours are limited that we could even get in there. And I imagine with all the changes that the universities have put in the last 2 weeks, that they're making us jump through like 3 separate security checkpoints to get into the building at this point.
And my other thought was that the staffing may be down, so that if you were going to say, give me the records of X, Y, or Z, for example, how many people accessed the collection between, this year and that year, they might not have people to do that. So that's why I sort of built in more days than I would have wanted to build in.
Okay. Well, I guess let me just leave it as I will work with Brian and seeing if what we can come up with. And then if we can't come to an agreement, of course, we'll send up the smoke signal and we'll the flare flag and call you back in to see what we can work out. But I suspect we've worked quite well together already. I don't see why we won't be able to find an adequate solution between the two of us.
Great. You guys are a delight to work with, especially compared with some of the other good lawyers I've met in this gig, but at least you try to find a path. So the court is very appreciative of that. Okay, so I think you understand.
Well, I was bummed that you didn't send the marshals out to go arrest them for contempt today, but shucks, but.
Well, who said it? Which president or said something like, it's their order, let them go enforce it.
Yeah, right.
It's the Supreme Court's order, let them enforce it. Don't have that power.
Yeah.
Okay, guys, anything else? I'm going to tell you that, I hope to see something in a week. Generally, you guys are pretty swift, so I'm not worried about it. And if in a week you can't find consensus, let me know and we'll get back together.
Let me just make sure I understand, Judge. You're looking for this in the sampling, leaving kind of open, giving us a wide berth. You're not looking for them to produce something to us, but rather make some kind of paper record coming back in some fashion.
Right. And obviously,
okay.
This will be done as an officer of the court. Mr. Schwartz will tell, I have no doubt that it will be accurate, none at all. So
Right. Okay. All right. Thank you for your time today.
thank you both. Have a good one. Stay safe.
I was
Thank you,
gonna
Ms.
say, so
Roberts.
Court of Appeals, Court of Claims and teaching, do you go home ever?
Well, you know my husband? He's
I
never
do.
home, so what difference does it make? We meet at dinner. So Ms. Roberts, you know what? I would like a copy of this, please. And I don't know if council will, but the court would like to order a copy.
Okay.
I'm Ms. Roberts, I'm good. I don't need anything right now with that. Thank you, though.
Yeah, I do not need it right now. Thank you.
All right. Thanks, Judge.
Thank you both.
you.
Okay. Bye-bye.